All right, good afternoon, everyone. I hope that you all enjoyed lunch. Our first panel this afternoon is titled Intellectual Property Legislation in the New Age. So we had our keynote speaker mention and talk a little bit about the Music Modernization Act. The panel that we have for you this afternoon is going to talk a little bit more about intellectual property law reform broadly and some of the challenges to that reform. The moderator for this panel is Professor David Taylor. He's the Robert G. Storey Distinguished Faculty Fellow and also the co-director of the Tsai Center for Law, Science, and Innovation and an associate professor here at SMU Dedman School of Law, and I will turn the panel over to him.
All right. This panel is all about IP legislation and with the idea of kind of looking backwards as well as looking forward, right? What changes have been made to intellectual property law through Congress and, signed into law by the president, and what are kind of the current controversies and prospects for reform through legislation. So I've got a great panel here. So let me do real quick introductions, and I'm just going to highlight, we're going to get to the substance, so I won't spend a lot of time on introductions, but as I mentioned this morning, there's a more detailed bios in the packet that you picked up when you signed in this morning. So to my immediate right, Sharon Israel. She's a partner at Shook, Hardy & Bacon in Houston. Hans Sauer is next. He's a Deputy General Counsel and Vice President for Intellectual Property at the Biotechnology Innovation Organization, Bio. And there on my far right, Tom Clees. He's the Vice President, Federal Public Policy for the Recording Industry Association of America. So I provided brief introductions, but I did want you, panelists, to actually provide more detail and fill in the blanks a little bit, help our audience understand your unique perspective, and so give more on your background, your experience related to legislation generally, and legislation in particular in the area of intellectual property specifically. So Tom, we'll start with you.
Sure. So I am actually the newest person in the IP world. I come from political world, so my practice as an attorney was in campaign finance and election law. I worked on Capitol Hill after that for a member of the House and for a member of the Senate as a chief counsel for both of them. And I had IP in my portfolio working on the Hill, but it was never my sole focus. And then I was recruited by the Recording Industry Association of America after the 2018 midterms to come and help them build up their public policy shop under the new CEO. So I've had the opportunity to do that, which has really consisted of me reading Don Passman's book a lot. If I could recommend it, I recommend it very highly, especially for anybody who wants to get the unvarnished truth of what goes on in the industry. It's on the desk of every person that I know, and it's just a fantastic resource.
Great. Hans?
So I work for an industry organization. I've been doing this job for about 13 years. I joined Bio coming from in-house at biotech companies as a patent lawyer. Going to a trade association was quite a change, I think, in the kind of practice that I was able to engage in. In this work, since 2006, I've been involved in negotiating the America Invents Act on behalf of our members, the Biotech Companies of America. So that was a very big piece of legislation as patent legislation goes. Subsequently, I was able to be involved in follow-up legislative attempts throughout 2013 to 15 to engage in more patent litigation reform directed bills. I was also involved in the Biologics Price Competition and Innovation Act, so that's a more regulatory type law that regulates the market entry of biosimilar drugs. So that's been an interesting ride. I've seen bills being made, passed, sometimes stall, that were of great importance to the biotech industry in the US, and I wouldn't miss it. It's been illuminating, also sometimes disheartening, but that's kind of my take on legislation, at least to the extent I've been involved.
Disheartening when it passes or when it fails, maybe is my question. But
also seeing it be made, and
Okay.
Sometimes when it fails, sometimes not letting it pass is the victory. Well, and it makes you wonder, what have I achieved over the last 5 years? Because I have nothing to show other than some bills that didn't become law. Doesn't feel very constructive.
Okay. Sharon, what about your background?
Sure. So I'm an IP litigator by practice. My legislative experience or IP legislative experience comes more from my bar association activities. I'm a past president of AIPLA, the American Intellectual Property Law Association, and I've done a lot of work for AIPLA in particular on the IP legislative front for probably about 15 years or more. Everything from, I actually chaired a special committee they had on the PAC, on the Political Action Committee, when I was on the board from 2005 to 2008. We were involved in AIA-related activities at that time. I helped to form AIPLA's Committee on Legislation. I chaired it for a few years. When I was president of AIPLA, I was actively involved in a lot of our advocacy efforts. Did go to various meetings on the Hill with staffers. I was also involved in help form. AIPLA has a task force on 101. I formed that when I was president, and I'm still a member of that task force. I'm also now a member, along with David, of a new task force on Arthrex and in the dealing with appointments clause issues, which I think we'll get into a little bit later. So I'm overall more of the IP legislative and policy wonk wannabe. My interest has been mostly from the practitioner standpoint and from the bar association standpoint.
Great. So let's go back to Tom. I want to start, Tom, with you because of your background. You actually worked on the Hill, and when I say worked on the Hill, you were actually paid to work on the Hill, not as a lobbyist, but on the inside, so to speak. So I'm interested, what in general drives individual legislators to get legislation passed? And if you could describe more about the process. And for example, when does legislation die? Why does it die versus get enacted?
Sure. So a way to look at it, separating it out from the individual personalities of each lawmaker, which they're all radically different, and some of them are very strange. Every political office is born every 2 years, every Congress, with a limited amount of political capital. Political capital is a function of the amount of time that member has left in office, the legislative calendar. Sometimes, there are things that have to be done. For example, Congress needs to figure out how it's going to fund the government for the rest of the year sometime around this June. That also has to do with the needs and the challenges of the constituency, what it's going to take for that member to get reelected in terms of campaign finance, in terms of the political reactions of any action that they make back home. So every single time that a bill is drafted, the drafting part is theoretical. That's when we get to be academics. That's when we get to have pie-in-the-sky ideas and talk to people who have really great insight. But the moment of introduction is when the bill goes from being theoretical to political. If an individual member of Congress is going to devote the time and the political capital that it takes to, cash in chits that they may have with other members, to use their relationships, to use their prestige and their time, that takes a serious investment. It has to be worth it for that member, and not just because the legislation happens to be a good idea that may lead to a more efficient social outcome. So, when I was a staffer, would bring me a draft bill, it could be absolutely fantastic. It could be a great idea. It could be something that, may address a problem that I know exists. But you're always going to have to tell me why I should care and why my boss should care. My boss is in the middle of getting a lot of things done at any given time, addressing literally every political constituency that exists in their state. Why should I do that? And that's a political question. But to the concept of legislation dying, death is not always a bad thing. There is a lot of legislation that is introduced solely for the purpose of getting a conversation started or for the purpose of existing. It's never going to get a hearing. It's out there maybe to light a fire under somebody to get something done. For example, there may be, even just in the case of copyright, which I'm sure we'll talk about the DMCA later, there is a series of hearings happening right now in the Senate Judiciary Committee IP subcommittee on the DMCA. And the ostensible idea of those hearings is to lead to legislation. there are plenty of stakeholders on both sides of the DMCA safe harbor question that in their heart of hearts do not want to see a bill and do not want to be negotiating their rights with Congress. But maybe this lights a fire to have some market-driven solutions at the end of the day. So people legislate for all kinds of reasons. They choose not to legislate for all kinds of reasons. And from a stakeholder's perspective, on the other side of it, sometimes you can spend entire years of your life making sure that nothing happens, and that's a pretty good deliverable in some contexts.
All right, so now beyond the overall process, I want to get more specific. And Hans, I want to start with you. You mentioned when you were discussing your background that you worked on the American Invents Act in terms of going up on Capitol Hill and participating in meetings, and that actually did become law. And in fact, I'd say it's our most significant patent reform legislation since 1952. It was passed in 2011. So if you can, just describe that legislation, how the push for the legislation began, how the negotiations worked, and how the compromise resulted that, President Obama signed it into law.
Okay, well, okay, good. So I think the history of the America Invents Act goes back to, like in earnest, goes back to around 2004, 2005. And I think those of you who are in patents, if you put yourself back then, I think there were several veins that led to the time being right, if you will, for a serious legislative effort that looked like it was going to have legs and pass. Now remember, this took 3 Congresses, so that's, I think, another thing to keep in mind, that big bills often take multiple Congresses. Another thing that often happens, by the way, is that driving the bill moves between the houses of Congress. So we might have like big legislative efforts start in the House, and in the next Congress, it's, if you will, Senate's turn to advance the legislation further until eventually it gets passed, right? So these are all, I think, elements that we often see with big bills. As the America Invents Act in particular goes, so what made the time right? Think back to about 2005, 2006. There were several veins, I think, that led to the atmospherics of the time. All right, so one thing that people were complaining about was there are issues with patent litigation, frivolous patent assertion, what problems in the system caused by too much litigation and litigation abuse. That was part of the narrative. And I think, what led in part to that was years before, like the burst, for example, of the dot-com bubble. What that had created a large inventory of patents from companies that were otherwise defunct. But the patents were in the system, they changed hands, they were beginning to be accumulated elsewhere, right? So that was part of, I think, what led to, I think, an impetus to think about, well, should we do something to the Patent Act? At the same time, there had come to be like a buildup of patent applications in the patent office, examination backlogs that were much bigger than what they are today, right? At the time, people had to wait 4 or 5 years after filing a patent application before they would get a patent out of the patent office. There was a great concern. The patent office was one of those stakeholders who felt that they were systematically under-resourced. They had a problem with fee diversions, where people who pay fees for patent examination later find that large amounts of those fees were funneled out of the patent office into the general treasury, weren't actually used to examine patent applications. Right? So that was another constituency. But a third thing perhaps to keep in mind was there was leftover work to be done from the American Inventors Protection Act, which had passed in 1999. I'm talking about 2005. Right, where perhaps it was going to be time to change some of the substantive U.S. patent law and go from, those of you who are in patents will know what I'm talking about, go from a first to invent system to a first inventor to file system like the rest of the world, to establish who gets priority to an invention when they apply for a patent. I think we also came off a period of relative calm in the development of patent law in the early 2000s, right? The Supreme Court, unlike today, had not been routinely stepping into patent law. And, there were not a lot of disruptive case law developments, I think, that had been going on for a long time. So that by some accounts, people were saying maybe the Federal Circuit, which was like the main court of driving the development of patent law, had done enough of the incremental work over a decade and a half of developing patent law, had perhaps reached the limits of what it could achieve within the constraints of the existing written law, and maybe it was time to modernize US patent law, which really hadn't been modernized since the 1950s in any meaningful way, right? So a bunch of, I think, streams that came together, together with interested stakeholders who all wanted different things, right? Some companies who complained about too much patent litigation wanted patent litigation reform. Other companies just felt they wanted more certainty in the system by reforming substantive patent law. The patent office wanted more resources and more money. So it was a confluence of stakeholders, which I think caused Congress to take its legislative initiative seriously, round up a large number of members of Congress who were willing to go along, and somehow, these bills came to have legs. Now, over time, there came to be very deep disagreements over the direction the bill should take. There was, if you give me one more minute, a sense when the process started, the legislative process started, people were saying, oh, you know, the way patent litigation is done in the United States is that a number of large US companies get together, they talk, and they will settle patent law for the rest of us. Well, that's how it's always been done. And that's not how this bill developed, certainly not during its early years. The bill did not advance fast. There was a lot of disagreement. There were new stakeholders who became very squeaky wheels, who had never had a voice in patent law reform, small inventors, small patent-dependent tech companies, and others. And that caused complications, sometimes to the chagrin of large incumbent patent-holding companies in the United States who didn't enjoy this kind of interference in an otherwise orderly legislative process. I think it took two Congresses before, especially the divisions between the big high-tech companies that wanted patent damages, patent remedies reform, patent litigation reform. So that was one block of large, well-funded US stakeholders. The divisions between those and other US manufacturing companies, including the pharma and the biotech industry, which by and large has a different take on the role of IP rights. When these divisions began to be bridged, well, that's when the bill started moving. And I think it's no coincidence, something we can get back to that later, that the America Invents Act, in the form in which it was finally passed, in my opinion, did end up having large company fingerprints on it in the way it was structured. I think most people will agree that this legislation, at the end of the day, does benefit large corporations more than it benefits small inventors and small patent-dependent businesses. That is no coincidence. I will leave you with like the one big thing that caused the very greatest disagreement during the negotiation of the America Invents Act, and that was how to measure damages for patent infringement. Right, I remember for two Congresses, that was the stumbling block. It was what held up everything. And the bill only started moving after the whole issue was taken off the table, and the America Invents Act at the end of the day contained virtually nothing about measuring the value of IP rights and the cost of infringement. Right, when that was taken out of the bill, it became feasible to move it. And I think the high-tech stakeholders who had up till that point insisted on such provisions of the bill agreed to their exclusion under the expectation they would be able to take a second run at these kinds of provisions after the America Invents Act was passed, and would obtain a second round of reforms that would be more patent litigation reform. And indeed, such attempts did happen in 2013, 2014, 2015, and those died, right, probably against expectations at the time. And those were very hard-fought battles.
Well, passed the House, but failed in the Senate, at least one of those.
That's where
bills.
a lot of bills go to die, sometimes for the better. Senate is the graveyard of bills, right? Very much.
And perhaps not surprisingly, the Supreme Court has taken several cases and been presented with several cases on damages in design patents as well as utility patents. Well, let me go and let's go back to Tom, actually, before I get to you, Sharon, and talk about copyright law and the Music Modernization Act. So, Tom, you participated in that legislative process. So, similarly to what Hans just described, can you describe in general the legislation, the process that led to its enactment, and how enough support was gathered for it to pass?
Yeah, absolutely. So Professor Passman did a really good job of explaining the base text of the Music Modernization Act, which was the streamlining of the compulsory license for the mechanical royalty, which is the composer's royalty in a song. But the Music Modernization Act, as it ended up actually passing, was actually 3 different bills bundled together, each of those bills representing a compromise amongst some set of stakeholders within the music community. So the second title of the Music Modernization Act was actually the Classics Act, which restored copyright protections for songs that were made before 1972. Previous to this point, there was no federal protection for those works. There was a patchwork of state works and a lot of uncertainty as to whether or not a given state was going to recognize a copyright in a pre-72 work. And then the third bill in there was the AMP Act, which was a bill that made it cleared up some ambiguities as to whether Sound Exchange, which is the clearinghouse for the performance royalties for digitally streamed music, whether those royalties a portion of them can be directed to creative professionals who are in the studio, so sound engineers, mixers, that sort of thing. So to Hans's point, the Music Modernization Act was the product of about 5 years of negotiation. And even before that, it's the product of a lot of grievances that the collective development and history of the music industry. For example, something that was constantly being put in and taken out of the Music Modernization Act final text was a terrestrial performance right, which, as a lot of you know, AM/FM radio doesn't have to pay a performance right to performers for recorded works for things that are played on the radio. So every time I Will Always Love You gets played on the radio, Dolly Parton, the composer, gets money, but Whitney Houston never saw $1 of that. So that's how it has always been done. A lot of folks who are competing with major radio broadcasters, for example, Sirius XM, Pandora, Spotify, they're all competing for your time in the car. They have wanted to even that playing field, and that has been a major stumbling block of legislation for a long time. And ultimately, that had to come out of the text before it could actually be agreed to. And just for reference, when the Music Modernization Act actually passed, it was passed by a roll call vote in both chambers of Congress, a unanimous vote, 0 votes against, which just doesn't happen. Especially it doesn't happen if you don't have an industry that has settled it all and figured out what they want in the bill and not in the bill before it comes to a vote. And the one thing that I will say about why it was successful is that for every single compromise that was made at each different part of the Music Modernization Act, there was a distribution of risk that made the status quo less desirable than getting something passed. I think it's really helpful to imagine Congress as sort of like a very big, very strangely, very poorly engineered hydraulic engine of some kind, where if there's any opportunity for there to be a pressure release valve and for to not spit out legislation at the end of the day, they absolutely will do that. There are many conversations to, can we just leave this for now? Do we have to do this? We only have 3 more weeks left in the legislative session, and then we're all going to go home for August recess, which is when we're going to make some really critical fundraising time, and we have a challenger this time around, and blah, blah, blah. So, if you just look at the mechanical collective, the mechanical licensing collective, there was uncertainty on all sides. The DSPs did not want to keep getting sued. Small publishers did not want to keep suing, like the major publishers did not want to continue existing in this space of uncertainty. And so by creating a compromise, you actually took uncertainty away, and a lot of the pending litigation was resolved in the course of making this piece of legislation. So I know I sort of keep coming back to this point, but it really takes more than just having the right answer or just having a favorable public policy outcome to make legislation move. Like, you have to actually create pressure that's going to prevent, for example, Senator Wyden from putting a hold on it just because he can, and to extract concessions on behalf of the Electronic Frontier Foundation. Like, you have to create the maximum amount of pressure on leadership all the way down.
All right. Well, Sharon, I want to go to you. I want to shift the discussion now to pending legislation or the push for legislation. So let's start with what's called the Stronger Patents Act and other legislation tied to the Patent Trial and Appeal Board. For example, perhaps with respect to the Arthrick's decision you mentioned earlier, which was a Federal Circuit decision holding that the appointment of the judges, the administrative patent judges on the Patent Trial and Appeal Board, the holding there was that their appointment violated the U.S. Constitution's Appointments Clause, and so there's potential for legislation related to that decision. So from your perspective, what would patent practitioners like to see happen in terms of legislation related to the PTAB, and do you see any prospect for reform?
Thanks, David. So first, first a disclaimer. So I'm going to say that whatever I say, my views should be attributed to me and not to my firm or its clients. But let me ask, just from an audience standpoint, do you know how many people actually know what an inter-parties review proceeding is, or a post-grant review proceeding?
Ooh,
Okay.
all right.
All right. So there's some people there's a lot of people who do, there's some people who may not. Part of what the AIA did was enact these administrative trial proceedings where it was supposed to be a cheaper, easier way to file challenges of, patentability challenges at the USPTO versus invalidity challenges in district court to patents. And as with any kind of legislation, when the AIA was enacted, there were a lot of people who started filing lots of inter-parties review challenges in particular, and challenging the patentability of patents at the PTAB. And the initial results were that the Patent Trial and Appeal Board, the panels were instituting trials in 85% of the +% of the proceedings, and of those instituted cases, it was highly likely that the petitioner, the challenger, was going to win, or at least win in large part. And patent owners were feeling feeling very threatened by these proceedings. So if they might go assert their patents in district court, they were finding that they were immediately being thrown into a proceeding before the PTAB, and their patents were maybe taken away at a high level. So we've seen since that time, in the first proceeding, so the AIA was enacted in September of 2011. The first IPR proceedings, the trial proceedings, began where you could actually start filing them a year later in September of 2012. And then we started seeing our first actual decisions come in about some decisions from the PTAB, and then appeals started in 2014. And now I can tell you appeals from the decisions from the PTAB constitute, or from the USPTO, constitute about 40+% of the Federal Circuit's docket. By comparison, 20 years ago, it probably constituted about 10% of their docket. So it's been a sea change. And as a result, I think we have seen a number of attempts at legislating. Do we need to do something to fix it? And we've also seen a change since the enactment of the AIA and these trial proceedings. We've seen a change at the Patent Office. We've got a different director. So we have Director Andre Iancu. Previously, for most of before that we had Michelle Lee. Before that we had Dave Kapos, and then an interim time period as well. And we've seen some different changes from, the Patent Office seems to do different things from director to director. So one of the things with legislation is it can help create some more certainty. So what do practitioners want to see? I think to some extent they want to see some more certainty and stabilization. Now, David mentioned the Stronger Patents Act. So what is that? I mean, there have been in different legislation gets discussed or gets introduced from time to time. The Stronger Patents Act was actually it's as you'll find with most legislation, they've got funky acronyms that I think Tom can probably tell us more about this, but I think staffers sit around and try to figure out an acronym so they can fill in the words to come up with what they want.
The key piece of a good piece of legislation is a solid acronym. You would not believe how often staffers after hours will sit around with a six-pack of beer trying to figure out the catchiest acronym.
So stronger is support technology and research for our nation's growth and economic resilience.
How could you oppose that? Come on.
And the bill itself was bipartisan, so it was and bicameral. So it was introduced in both the House and the Senate Judiciary Committees, in the relevant subcommittees on July 10th of last year, and has bipartisan support. The Senate subcommittee on intellectual property held a hearing in September on innovation in America, how Congress can make our patent system stronger. Got that acronym in there again. And they had several witnesses who testified, and at the end of it, what we basically heard was the Chairman Tillis, express some concerns that there were diverse views and we had work to do if this was going to go anywhere. The kind of things that are in that bill include IPR, PTAB related reforms that would include like expanding the estoppel effect. So if you file an inter-parties review proceeding and you lose, you're going to be stopped, or you win. You could be stopped from raising the same challenge in district court. You pick your place, you do it. But there's been some, this would kind of expand some of the estoppel. And there's also, it's not just the party that brings the petition, the challenge. It would also applies to their privies or real parties in interest. And so there's some questions that have been out there as to who's a real party in interest. There's kind of litigation about that. So part of the act would more define who's a real party in interest. It gets into some procedural issues in terms of stays and what happens with district court proceedings or proceedings before the International Trade Commission. And there's some other issues that deal with codifying what the claim construction standard should be. So we've got regulations. The PTAB came out and said they changed what the claim construction standard would be. So there's a proposal as part of the Stronger Patents Act to codify that as part of the legislation. And it includes ways of dealing with some serial petitions. So if somebody where a patent owner basically wouldn't be subject to more than one challenge on a patent. I mean, those are sort of flavors of it. But it also goes beyond that. It goes beyond some of the PTAB-related reforms and gets into actually even ex parte reexamination, which is something we've had for a long time. And it would say that ex parte reexamination would be barred by a civil action, that you wouldn't be able to institute an ex parte reexamination if it was filed more than 1 year after the time that a requester or its privy was served with a complaint alleging infringement. So this would even be a reform on what we've traditionally had, or traditionally as long as we've had the ability to file ex parte reexaminations, would even be a reform on that. And there's one section in it that's restoration of patents as property rights, which, what does that mean? It sounds okay at one level, but it actually kind of addresses the Supreme Court's eBay decision in part, because it deals with there would be a presumption of irreparable injury if a patent's found infringed and not invalid or unenforceable, and a presumption that remedies available at law would be inadequate to compensate for the injury. So it would open up, now you'd have that presumption that we haven't really had since the eBay decision. And then there's some other things. We always usually see something like eliminating fee diversion from the USPTO as part of these acts. And there's one bill that's included with it that's been introduced Congress after Congress after Congress, and that's what's called the Troll Act, the TROL Act, for targeting rogue and opaque letters. And that deals actually with creating national uniform standards for dealing with fraudulent demand letters, because there's all these different states that have enacted different bills to deal with fraudulent demand letter assertions. So that's a little bit of a flavor of that.
So stronger patents within the troll. Sounds like the opposite perspectives kind of. Let me ask about another topic, and Sharon, I'll stick with you. Near and dear to my heart, you mentioned you actually formed the patentability or patentable subject matter task force at the AIPLA, and I was a part of that. And so I've written 5 or 6 law review articles on point. I'm a big proponent of reform in the area of patent eligibility law. So I want to ask you, from the patent practitioner perspective, what do we want to see happen in terms of legislation related to patent eligibility, and what is there any real prospect for reform?
So, again, these are my views. 'Cause I've been on all sides of these issues, so I take advantage of the law as it currently stands when I do what I can to act zealously for my clients. But so, I think this is an area where we would like to see more balance and certainty overall. There are various views on 101 related reform, patent eligibility. There has been a lot of activity, and if you look, and kind of in the same time, some of this is in the same time frame. If you look and see the number of challenges in litigation under Section 101, it has become somewhat as just the norm, that you may see motions to dismiss, motions for summary judgment, but it's very common in litigation, and also on the office side at the USPTO, we've seen just for a while kind of paralysis, at least in some art units, where a lot of applications were just getting held up because the Federal Circuit kept issuing new decisions, and the office was trying to kind of chase those decisions and try to figure out what's the latest law and how do we apply it, and patent examiners didn't know what to do. So I think practitioners want to see some certainty. Now what's happened, there's definitely been groups that have been interested for a long time, including AIPLA and others, and there's a lot of different voices in the industry that have different interests. The most productive thing that I think I've seen was over the past year. There was, in April of last year, there was some bipartisan, bicameral activity where, starting in April of last year, Senator Coons and Tillis and Representatives Collins, Johnson, and Stivers released a 101 framework of what they thought, an outline of what Section 101 reform should look like. And they gave some criteria there. And one of the things they said was eliminating abrogating the judicially created exceptions to patent eligible subject matter, which are abstract ideas, laws of nature, natural phenomena, in favor of like statutory categories of ineligible subject matter. And then they they released some draft text in May of last year that made some changes, including abrogating the judicial exceptions, and it did some other things, though. It added in a definition of what useful should mean. And then it also came up with somewhat surprisingly, it came up with changes to Section 112F to deal with, which is what we use for means plus function claiming, or what applies for means plus function claiming currently, and dealing with functional claim elements more generally, and trying to deal with, concerns of how functional claiming is applied. How does that exactly apply to Section 101? clearly there was some negotiation going on as to trying to appease different interest groups. So I think one of the things that in my view would be most productive there would be probably eliminating the judicial exceptions. How they're applied or how they can be applied has become very difficult. It's in the Federal Circuit, we've seen its cry for help in a number of decisions saying, we're stuck. And there's been Federal Circuit judges, including one I clerked for, who has said, this seems to be an area where legislation's needed. The likelihood that we're going to get anything further from the Supreme Court seems unlikely, given that they have declined to grant cert in a number of cases where the issues seem to be presented, and including one that seemed to be presented would be a good vehicle to address the issue. So I think we're at a place where we do need legislation there.
All right, Hans, let me go back to you and first ask for your view, and I guess Bio's view on pending legislation. We talked about patent eligibility, reform to the PTAB. Is there patent legislation that's good, bad?
Well, I think certainly there's legislation that's well-intentioned and that tries to address the problem. So picture this. So, roughly, yes, Bio is supporting some forms of legislation, even though this may not be the ideal Congress to advance patent legislation of any kind. There are problems that we do feel deserve to be addressed. So when we go back to the Patent Trial and Appeal Board proceedings, picture this, right? You're a patent owner, and you detect infringement of your patent by a competitor. You're losing sales. These people are eating your lunch, selling knockoff widgets of what you've patented, right? So you go sue them, predictably, and you end up litigating against them for about a year, right? They start taking some discovery. There's claim construction hearings in district court. About a year into the litigation, you find that your adversary prepares a petition to the Patent Trial and Appeal Board and opens a second front of litigation over there in the patent office, a different forum, right, where they take the same patent to a different decision maker, right, who can interpret the patent claims differently from the way your federal judge is doing in your ongoing litigation, where the standard of proof is lower for invalidation than it is in district court. So your adversary basically took what they learned during a year of litigating against you to open up this second front, to come in with a well-developed narrative in a different forum, again, where the same patent is evaluated by a different decision maker under different standards of proof at the same time. Right? The only goal to do this, the only purpose why people would do this, is to take a second bite at the apple, right? To hedge against the outcome of the ongoing district court litigation, perhaps to stall the district court litigation until a PTAB proceeding plays out. So that was never intended when the America Invents Act was negotiated, right? The narrative there was, and you said it was to create, a forum that would unburden the district courts, that would allow for a quicker but as equally reliable determination of the patent's validity, a quick take, if you will, on whether the patent is valid or not. That's going to unburden the courts. It's going to lead to quicker resolution of commercial disputes. It's going to lead to more commercial certainty. That was, a great, I think, story around the PTAB proceedings, but all too often these proceedings, instead of creating certainty quicker, have perpetuated disputes instead of resolving them sooner, and they have caused inconsistent outcomes. There have been cases, right? And try and explain this to a business decision maker, where the same patent that's been upheld in district court, where you had a federal judge saying this patent is not invalid and it's infringed, and that gets appealed to the Federal Circuit, and the Federal Circuit says, yep, that's right, that was a correct decision. And then the same patent comes up on appeal from the Patent Trial and Appeal Board, where it was held invalid, and the Federal Circuit looks at that decision and says, yeah, that's correct too. Right? It's invalid, and because under that standard of proof, it was properly shown. right? So try and tell that to a business decision maker whose mind wasn't warped by law school. Why are they going to say, well, one of them's got to be wrong, right? And we have to say, no, boss, like they're both right. But the only thing that matters is that your patent went down once, because that's the bane of the patent holder, right? You have to lose only once. You have to win every time against every infringer, right? But you have to lose only once, right? And then your patent is gone forever, right? And that's hard, I think, for a business that said, well, we invested like in this patent, in the belief that, you know, we have a solid patent that was issued by the PTO. We spent money. We built our business around this IP, right? And the worst thing, actually, that can happen is if it later gets invalidated because of an intervening change in the law. And that's my tie to the Section 101 discussion, right? Every now and then, there really is a change in substantive patent law that happens as a result of adjudication in the courts of judicial decision-making, where patents that were perfectly valid when they were examined and issued become invalid because the law changes, right? And the PTAB is like one such forum for particularly leveraging such changes in the law and invalidating patents whose invalidity nobody could have foreseen. And that's, I think, a really unfair kind of situation that is very bad for investment in innovation, because no matter how much the patentee and the patent applicant could have tried at the time to get a valid patent, they couldn't have foreseen that the law would change years later and the patent becomes invalid, right? So these are themes that we often hear at Bio from our member companies, most of which are small companies that actually don't have products on the market, right? It's not all the big drug makers who are organized within Bio. It's small biotech companies that have another 15 years to go before, if ever, they have a product, right? These companies say it's really quite intolerable to have situations where patents become invalid because of changes in the law, or where patents can be invalidated in repetitive proceedings, right? There's not a limit on the number of IPR proceedings that can be brought against a patent. So yes, there are areas we do support elements of the Stronger Patents Act. I personally don't think this Congress is going to be the time when it gains enough support, right? It's been there for 2 Congresses without much action. And likewise, the question of reforming patent-eligible subject matter is something that is currently, to my mind, mainly back in the hands of proponents and demandeurs on the stakeholder side. So the groups that want that kind of reform to substantive patent law is a very heterogeneous group, where it comprises interests from the life sciences as well as from high technology, from software. There are big companies whose names you would recognize who are very much in favor of reform of that curious area of the law. But here's one problem that I do see with the current posture of efforts on reforming patent-eligible subject matter. So Congress, or the congressional offices who were holding the hearings on Section 101 reform last summer, right, they took in information and proposals on what legislation should look like during a series of stakeholder roundtable meetings. They surveyed all the proposals that they got, and they concluded that what people were proposing, all these stakeholders who got together saying we need 101 reform, the only thing these people really all agreed on was that they hate the current state of the law in this space. And the legislative proposals that gained consensus among this heterogeneous group of people were proposals that would largely turn back the clock to about like 2009, 2008, but wouldn't do much more, right? Go back to what it was like before. That's what people could agree to. And the offices in the Senate, they looked at this and they said, no, we cannot just turn back the clock, right? We will agree to push reform in this space forward, but you will have to help us do at least 3 things that we do want to do as part of this reform effort. First, you know, we no longer want to have patents on things that really aren't technology at all, right? You know, pure accounting methods that aren't even implemented on technology, right? There was a case called Bilski, which was a method of commodities trading that didn't even require computers, right? It was a step of business acts that were laid out in the claims. Or, people often say, oh, the patents on marriage proposals and dance moves, and we got to get rid of that. So the congressional office said, help us with that, right? Non-technological inventions should be addressed as part of this reform. Help us with the following also, the so-called do it on a computer claim, right? So your dance move or your marriage proposal, but implemented in the form of an app or implemented in other conventional technology, so that nominally when you read the patent claim, it actually does look like it's about technology. It talks about computers, servers, memory, or whatever it might be, right? It's a much harder case to talk about the so-called the non-technological invention that is implemented using conventional technology in a patent claim. I think a rather intractable problem in US patent law, because these claims do come out nominally novel and unobvious. They do on their face meet all the conventional requirements of patent law. And yet there are a lot of misgivings about these claims. They're often not allowable in Europe. They're allowable here. Why is that? Right? So help us with that. And the third thing Congress said was help us with like the broad, abstract looking, functionally claimed claim of any kind. So let's address these three tasks, they said, right? And then we can talk about further reform. And that's been hard, right? Because if you come back with a task and say, do these three things for us in a large and heterogeneous group of stakeholders who all want reform, but who come from different industry sectors, it gets difficult, right? And just imagine you're a big corporation who spends billions of dollars on artificial intelligence applications. Right? Are you going to get worried when Congress talks about, we're not quite sure whether we like you do it on a computer claim, right? You might have an artificial intelligence that learns how to drive a car, like by recognizing patterns and all sorts of stuff that happens out in the real world. And the computer learns, right? But is that really an innovation of the computer? The computer is as it always was, right? You have a smart computer program that does what the human mind could do. But is that technology? I'm not sure I want to find out, right, if I'm a company that has billions of dollars invested in this. Anyway, so that's my take on this. I think it's going to take time. I think, we need to have a real heart-to-heart among the stakeholders of reform. And until that happens, the offices that were interested in 101 reform said, forget it, we're going to do copyright hearings. A lot of them.
Speaking of.
For what it's worth, all my dance moves are in the public domain.
All right. Well, Tom, let's talk about legislative reform in the copyright area. What are some of the pending bills, and is there any real prospect for Congress getting behind any of them? And kind of what's the status of copyright legislation?
So one of the really great after effects of the MMA is that we have all of these really great channels of communication that are open not only within the copyright community, but between the copyright community and staffers on the Hill who are interested in this sort of thing. So there's this great after effect where there's a lot of discussion going on, and some of those proposals are very disruptive to the status quo, and that's really cool. This is a really cool time to be looking into copyright. I don't know that we yet have a full suite of major copyright reforms that are ready to go, that are ready to pass through in the immediate future, either under this Congress or with the next administration. But there's some cool ideas, and I'll definitely talk about a couple of them. The first one's a really great acronym. It's the Ask Musicians for Music Act, or AMFM Act, by a really great pairing of legislators. So Chairman Jerry Nadler on the House Judiciary side, and then Senator Marsha Blackburn on the Senate side. So definitely not people that you see standing together a lot. But this is a bill that takes on the issue of the performance right for AM/FM terrestrial radio stations. And it does it in sort of a really interesting way that nobody's really tried before, that is great fodder for conversation. Rather than creating a right and then a compulsory license or a licensing scheme or anything like that, it just says that radio stations that want to use, and there's a carve out for smaller stations, so we're just talking about the majors here. If they want to use artists' music, then they just have to get consent, and it's that easy. And the reason why that's interesting is because one of the major arguments that the large broadcasters have used for a very long time is that, artists don't need to get paid by us because they benefit in exposure. And that really resonates with millennial Hill staffers when you tell them getting paid in exposure. So the idea that we're going to put that argument to the test is really interesting, to say, okay, well, if this is right, then why don't we just put this into law? And if you guys are correct in your assumption that artists don't want to get paid, then they will all give you consent, and that's where we'll leave it. I don't anticipate this to pass this Congress. It's a novel idea. I think that we'll have a great hearing on the House side probably, and it'll be a lot of great discussion. And I just think it's worth keeping on the radar because it's new and different. But I also do want to get back to the Senate IP subcommittee. Those very same staffers who were doing those series of roundtables, we're also doing it with them. And I have to seriously give a lot of praise to the staffers for Chairman Tillis and Ranking Member Coons, because I can't think of a time in the last 20 years or so, other than maybe under the period of time under Chairman Goodlatte in the House, when staffers wanted to dig this deep into DMCA. I mean, for a long time, anybody who was really familiar with the stakeholder intransigence here between content, between tech, within tech, they were smart enough politically to stay away from this stuff. And for them to want to dive in headfirst is really admirable. And it's been fun to see the energy in those hearings. I'm not sure what the legislative proposal at the end is going to look like. And I'm not sure how easy it's going to be or whether we're going to ultimately, be at an impasse or something. But what we could see, which is a really positive thing, is maybe some light to be shined on the major controversies within the DMCA, and for folks to think that maybe there's a market solution for some of these things. So, like, for example, for Congress to take the music industry and YouTube and bang our heads together and say, find consensus on one thing, we could say, okay, improve your encryption so that stream rippers have a harder time, stealing music. That's just one thing. Or make Content ID available to all creators across all channels. That's relatively simple. Senator Marsha Blackburn held a really great roundtable on Content ID where small creators came in and communicated their concerns, and the Google folks were good enough to come in and listen, and there was some conversations that resulted from after that. So there's definitely a few things that we could do right now without legislation to improve the relations between the content community and the tech community. And it's just a question of whether this exercise is going to create the sort of pressure for that to be better than the status quo.
Excellent. So let me ask this question for each of you, and I'll start sharing with you. Name 3 or 4 of the major players in patent reform legislation. Groups, companies, some of the most powerful. So as we think about how do you reach a consensus, or the hydraulic example where all that's left, everybody's upset about some area of the law, and so we'll agree to reform. Who needs to be persuaded who are the groups that are going to persuade Congress, I guess? If you had to name 3 or 4, whatever your number is, but who are the major players?
So you're not going to like my answer, but some of my answer is it depends.
Okay.
Because I think it depends what we're talking about. One of the issues that I didn't talk about, and I know we're running out of time, was just reform for the appointments clause issue with administrative patent judges. That's not going to be a super controversial issue, I don't think. I think that's one where, there may be some controversy, but I think that the interest, a lot of the groups, it's less likely, I think, that the tech companies are going to be at the forefront necessarily of that issue. I think that some of I like to think AIPLA is kind of looked at as a trusted advisor, and for things where there's sort of technical fixes that it's a good group to look to.
Yeah, until the bootstrap artists show up, right? And there's some kind of bill gets put together and going, I want like a piece in this legislation to it, just relates to the following. Right? Next guy finds, then in that case, I want something else too. And before you know it, it becomes a huge cluster.
Right.
Or not.
True.
Yes.
So, but I do think bigger issues like the 101 issue, you do see what I'm going to refer to largely as the tech industry. Part of that is Google and others. They have a very big voice, and they've got you know, they are constituents of some major players on the Hill.
Right, Hans, can you name 3 or 4? I mean, bio major player?
Is bio a major? Well, I want to think so. Well, I would say, this probably won't surprise if you follow, right? I think there does tend to be a bit of a block of like FANG-type companies, you know, large tech e-commerce companies do often align. I think based on their business model, they tend to think about IP in somewhat related ways, and they can align. So I think that's one block. But I think there's secondary actors on that side of the spectrum, right? Financial services, like the banks sometimes show up. It's weird, like retail federations show up. People get sued a lot for patent infringement show up. On the other side, I do think the life sciences, you know, pharma, biotech tends to be conservative about pushes for litigation. There are large tech companies. I'm just going to call out Qualcomm. Right, Qualcomm is a very significant company that, when you think about what they do, right, they don't manufacture stuff. They don't get sued a lot for infringement because they don't put out their own technology in the form of products. They are originators of inventions and technology that is widely licensed throughout the rest of the industry. So Qualcomm, as big as they are, you know, tends to think about patents a little differently. I do see them often on a pro-reform side where they take a side towards stronger IP rights. So I think that's roughly how it falls. I would be remiss to not mention various small inventor groups. I don't know how powerful they are at the end of the day, but they are very loud, and they get and they have an audience. Right? These people are angry people. Some of them. These are people. These are people who will go. They will show up, like a dozen or two of them, like with beards and angry with their kids and grandchildren. They will burn their patents on the steps of the patent office,
Literally.
in front of rolling cameras, right? And they will get coverage for that. And they say, "See, this is what our patents are worth nowadays," right? And so I want to mention them. I want to give them a shout out because they are a voice that we should have had all along.
And one of them may be coming to give an innovation lecture on April 2nd. So
You should really
you
come.
should
like
come.
Storey
I don't think he'll burn anything, but you never know. Well, Tom wrote, last question to you. Same question though. Who are the major players? RIAA maybe,
RIAA,
but
yeah.
in copyright. Yeah.
Yeah, so I think it's misleadingly easy to sort of divide it up between content creators and between sort of like the tech community, but I'm going to do that because I have 30 seconds. So, I mean, you have the major content producers. So we are the trade association that represents the major record labels. You know, there is another trade association that represents the major movie studios. There's another trade association that represents the major esports studios. And if you haven't looked at how much the video game industry is worth lately, it's worth taking a look. It is massive, and it's really the future in a lot of ways. So, even between and amongst those trade bodies, obviously, a trade organization's purpose is to focus on the areas of consensus within your companies, but at the end of the day, your companies are still competitors. And it's the same with each of those other trade bodies. So, the trade bodies are a really helpful way to see where those areas of consensus are emerging. They're less public about where they disagree, even though they do in sometimes. But it's the same on the tech side. There's a trade association for the tech platforms, the Internet Association. They're very, very relevant. And then, each side, there are sympathetic think tanks that are producing, scholarly literature that, each of these, it's in their interest to magnify, throughout the academic community and within the legal community and the political community. But, the way that I would define relevance is not necessarily, the ability to, get people to go burn something on the steps somewhere, although that's good TV. The ability to make political ads go into a different space, or the ability to marshal a huge fly into the Hill. It's just being in the room. So that when the staffers are getting ready to sit down and start drafting a bill, they shoot you an email and they say, "Let's get coffee and let's talk about what this might mean for you guys." And in order to have that, I think you need more than power. I think you need more than raw political know-how. I just think you need to build relationships, because at the end of the day, these are human beings. So, that access is a function of a trust, and you need that in order to be at the table and to be relevant.
All right, thanks. We could, keep asking questions, but we are out of time. So join me in thanking our panelists.